For the first time in 111 years, a president tried to fire a Federal Reserve governor. The Supreme Court stopped him. The decision determines whether the president can fire officials who run independent agencies whenever he wants, or whether courts and Congress can actually limit that power. Nine Robes uses nonpartisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided, it's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. In August 2025, President Trump moved to remove Federal Reserve Governor Lisa Cook. He claimed she committed mortgage fraud before taking office by listing two different properties as her primary residence within 2 weeks of each other. Cook sued to keep her job. A federal judge blocked her removal while the case proceeded. When the Trump administration asked the Supreme Court to overturn that order on an emergency basis, the court said no. The vote was 5-4. That might sound like a narrow legal ruling. It was not. The court's decision rested on 4 major conclusions that reshape how the president can fire federal officials. Courts can review whether the president actually had a valid reason. That reason must be substantial and genuine, not just any complaint. Courts can order an official to stay in their job while litigation continues. And most importantly, the president must give the official notice and a real chance to respond before firing them. Cook never got either. The court didn't comment on whether the mortgage fraud allegation actually justifies removal. The government's lawyer argued the president should have broad power to fire a Fed governor for almost any reason related to that person's conduct or fitness. No formal process needed. A social media post demanding Cook resign, plus 5 days to respond, was enough notice. Courts should have no power to put a removed officer back in place. Cook's lawyer countered that removing a Fed governor should require serious cause, similar to the standard used for other protected officials. He pointed to a 1903 Supreme Court case establishing that when Congress creates a fixed term for an office, the president must give notice and a hearing before removal, even if the law does not say so explicitly. He also noted that in over a century, no president had ever tried this before. The oral argument revealed the real stakes. Justice Kavanaugh warned that the government's position would seriously damage the Federal Reserve's independence. Once one administration uses these tools, others will follow. Justice Sotomayor questioned whether a social media post could ever count as fair notice. Chief Justice Roberts challenged that if courts cannot order reinstatement, why was the case before them at all? Chief Justice Roberts built the majority opinion by rejecting each of the government's core arguments. First, courts can review whether the president had a valid reason to fire a Fed governor. The government had already admitted that firing someone for no reason at all would be reviewable. That admission only makes sense if courts get to decide what counts as a valid reason. Second, the court rejected both sides' definitions of cause. The government's was too loose. Cook's was too narrow. Instead, the court held that cause must be substantial, reasonable, and just. The real question is whether the stated reason genuinely suggests the governor is unfit for the job, or whether it is simply a cover for replacing her with someone more agreeable to the president. The Federal Reserve's unique role in American economic life matters here. Congress designed the Fed to be independent, so the bar for removal should be higher than for other agencies. Third, the court held that the president must give notice and a real hearing before removal. A social media post does not qualify. Cook was entitled to know what evidence was being used against her, have a genuine opportunity to respond, and be given a deadline for doing so. Fourth, courts have the power to order an official to stay in their job while litigation proceeds. This is a long-standing practice in disputes over public offices. Justice Kavanaugh wrote separately to emphasize that this decision does not settle whether Cook can ultimately be removed. That depends on facts still being examined. But he stressed that the Federal Reserve can remain independent even after a companion decision the same day eliminated similar protections for most other independent agencies. Justice Jackson also concurred but argued the case could have been decided more simply. The government showed no real harm from leaving Cook in place. The only injury was the abstract frustration of having an officer serve against the president's wishes. Justice Thomas filed a sweeping dissent challenging nearly every part of the majority's reasoning. He argued that mortgage fraud plainly qualifies as cause for removal, that the statute's silence on process means Congress did not intend to require any, and that the law protecting Fed governors from removal without cause is itself unconstitutional. He warned that the majority's procedural rule would apply broadly across hundreds of federal statutes. Justice Alito objected to the court issuing a sweeping opinion on an emergency application when the record was still thin. The case was only 3 weeks old. Justice Barrett focused on the scope of the majority's opinion, troubled that the court ruled on the Fed's independence protections even though the government had not raised that argument. The law protecting Federal Reserve governors is deceptively simple. They serve 14-year terms and can only be removed for cause. Those few words carry enormous weight. This case forced the court to work through what cause actually means, what procedural rights the president must follow, and whether Congress can protect the Fed from presidential control at all. The court said Congress can. It grounded that answer in the historical tradition of the first and second banks of the United States, which Congress similarly insulated from direct presidential control. But that answer sits in tension with the companion decision issued the same day, which struck down similar protections for other agencies. Other institutions might someday claim the same historical protection. The Federal Reserve sets interest rates and manages the money supply. Those decisions affect your mortgage, your savings, and your job. The court just said the president cannot simply replace Fed officials who disagree with him. Without that independence, the Fed could become a tool of whoever sits in the White House. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.